Okay, so hello everyone, welcome to class. I am Amit Yadav. I am a plus educator teaching live on Unacademy. Okay, so today in this class we are going to deal with the topic of tribunals in India, right? So in this class we will see what is the meaning of these terms tribunals, uh, how they are originated, how they are different from courts, what is the purpose of their formation. Because I think tribunals is one such topics in which majority of the students they are having some issues. They are not clear with their fundamentals, their basics about what is the meaning of tribunals, and all these issues we will look into very briefly. We will go through all these issues in today's class, right? Now, before that, let me tell you something about Unacademy Learning app. You can simply download it from Play Store, at Google Play Store. It is available there. Now, there you would find two apps. One is Unacademy Educator app, that is basically meant for educators. You need not to download it. And the second one is Unacademy Learning app that you can download. Now, on this learning app, you will find two types of courses. One are free study material or your free special classes, free quiz, free test series, and lot number of free programs are running there. All you can access all of them free of cost. And second is your subscription, that is your plus or iconic subscription, where you can have batches and as I'm telling you in upcoming moments, a number of things are there available also. Okay, so uh, in case your application you can download it, and after downloading the application you have to go for with some basic registration like your mobile number and your email ID or things like that. Then if after that it asks for some that passcode or some referral code or any type of code, if the app is asking except OTP, then you can simply put there Amit Yadav Foundation. Okay, so simply by using this code, what will happen? Simply by using this code, you would be able to access all the free material. And if it is not asking any code, then no need to write anything. Chali. So what are the various benefits of having an academy learning app? Firstly, you can find structured batches with top educators. Means the batches have been planned according to the need and time available for your examination. The batches are available separately in Hindi medium, separately in English medium, and bilingual batches. Likewise, I am taking English medium batches there in plus. Late night batches for working professionals are there, as well as 2 year batches for undergraduates, that's UG programs or UG students. 100% of the syllabus coverage with the current affairs updation and daily current affairs. That is means, most tricky part of any UPSC preparation, that is there. Then all of the uh, I should say all of the your popular optional subjects like public administration, sociology, all of them are available there. Then there is a prelims test series with evaluation. Similarly, there is a mains test series with evaluation, followed by a dedicated doubt clearing class, daily current affairs practice, essay writing and answer writing practice, performance analysis of your test, of your classes, where you have performed well, what are your weaknesses, so that you can in the last hours of your examination you can go through the revision of those topics where you were able not to perform well in your test and or miss quiz and all that. Then sectional quiz would be there, and obviously interview preparation would be there. So these are all the benefits of having that Unacademy learning app. Otherwise you are studying on YouTube also. Sorry. Then on Unacademy you will find two types of subscription. One is iconic and another one is plus. In both of these subscription, you will have batches. You can have access to all the material available on the platform. But in Iconic, if you're having that Iconic subscription, then you would be allotted a personal mentor. Okay, so you would be having that benefit of that personal mentor, but that is only for Iconic subscribers, not for Plus subscribers. Then live class environment would be there, live polls, live doubt session, doubt clearing sessions, live interaction. All these things would be available to you in your plus classes as well as in your that I mean iconic classes, right? Then similarly I have told you iconic UPSC subscription, where you are having this extra benefit of one personal coach who would guide you through your examination preparation, and throughout your journey is going to guide you up till the time of your subscription. Live class environment, leaderboards, it means your rank when compared to your other of the colleagues who are giving tests. Then live doubt solving. I think every third and fourth class in my batch, every third and fourth class is doubt solving class. Live interaction, and every I think seventh or eighth class there is a quiz. So all these benefits you would be having if you are having Iconic or Plus subscription. But in Iconic you would be having some extra benefit of this personal coach. Sorry. Similarly, I've told you plus subscription, all the benefits of Iconic are there except this personal coach. Okay. Now, your fee for plus subscription for 2012 month it is 49,500. For 24 month it is 72,000, and for 36 month it is 90,000. Or in other words, you can say that it is around rupees for 12 month it is around rupees 120 per day. If you're taking for 24 months, then it is 100 rupees per day. And if you're taking for 3 years, then it is your, 80 rupees per day. Now see, just think by yourself. You are having classes from 7 a.m. in the morning to 12 midnight. Okay. Around 100 of the top educators are teaching you. You are having immensely helpful and n number of test series, quiz, or everything you are having. And what you are paying is 80 rupees per day. In that also, if you are using my code that is Amit Yadav Foundation, that you will get 10% off. So it comes out to be around 72 rupees per day. I don't think by any standard it is costly, or by any standard this fee is unreasonable or no, or something like that. Moreover, you are also having EMI option, so you can pay by EMI also, that you can check in your learner app also, right? Then, so these are the various subscriptions. After using my code, that is this Amit Yadav Foundation, 10% off would be there. So this would be your fee. You can calculate what is the daily amount which you are paying to Unacademy, and compare it with offline or somewhere else, and the rest you can know by yourself. I am not going to tell you all those things. Yeah? Just experience them by yourself only. Okay. Sorry. So now we have to start with our topic, that is the meaning of tribunal. In today's class, we would be having a quiz also. So stay with me in the class. Or if you say, so first we will host that quiz and then only we'll start with the class. Whatever you say. First you want to continue with the class, or first you want to go with a quiz. Very interesting quizzes there. For that you need not to do anything extra. Just you have to log in to that Unacademy platform. Okay, that is special classes. I am giving you a code that you have to join that quiz. Okay, see, whenever you are going to your learning platform, at the bottom it is showing subscription, browse, and there at the bottom, see, this is like, it is like this. Just try to understand. It is like this. Here in the bottom line, it would be written test or quiz, something test or quiz. You simply have to press this thing, and then there would be an option of join quiz. So I am starting the quiz. Just go to that platform and let's have it is only a 5 question, 20 seconds for each of the questions, so it will take us only 1 minute of us, but you would have a feel of means what is that to appear in those quizzes. And complete day these quizzes are being continued, so you can join them anytime as you wish. So let me give you a password. Yeah. You can join that by giving a passkey. I am giving you a passkey. Simply type it there. So your passkey is 25176 4. Okay. So you can join that quiz simply by using this passkey. Because I am starting the quiz, just hold on for a moment. And then we will continue with our class. Only 5 questions are there of 20 seconds each. तो देखो एक बार करके कितना सीखे हो, so that you can know where you actually stand, right? It is also one of the purpose. Just hold on. So I have given you the password. Sorry, I am resuming the quiz and it starts now. Sorry, it starts in 4, 3, 2, 1 seconds and starts now. Try to answer using your all the senses. Sorry. So what they are saying, the term judicial review has nowhere been used in the Constitution of India. And I will keep you giving hints. Remember Article 13. Both Supreme Court and High Court can declare the law enacted by Parliament. I have taught this thing in my special class only. Now it is up to you and try to answer it. Nobody has answered it. चलिए, coming on to next question. Only we need not only to attempt questions, सही भी तो करना है. Now this shows that what is the level of your preparation. ठीक है, that's why take subscription, come to plus classes, कुछ सीख भी जाओगे और at least attend all the YouTube and special classes. उतना तो attend करो. You people are not even attending those classes. कैसे काम चलेगा ऐसे? And these questions are very very simple. They are very basic type of questions are there in this quiz. ठीक है ना? चलिए next question. Try in this. Okay, so one more last question is there. One last question is there. उसे और कर लो फिर हम we'll continue with the class. चलिए. Okay, so thank you very much for this quiz, right? एक मिनट को. चलिए. चलिए. So let's continue with the class only. Just hold on. So we have to start with the this tribunals, right? चलिए. Good evening, Anshu beta. Very good evening. Very good evening. चलिए. So let's start with the class. Let's start with the quiz में आप लोग participate किया करो. At least if nothing is going to happen, then at least those 5 or 10 questions you are preparing, है ना? Every question is having 2 or 3 statements. So at least those 15-20 statements would become clear to you that they are right or they are wrong. And it hardly takes 1 or 2 minutes. क्या जा रहा है इसमें? At least participate in the quiz. Likewise, a very good question was there that means a High Court can declare laws as unconstitutional. So only those laws which are made by state legislature or the laws of what? Or the laws made by parliament also. So High Court can declare any law either made by parliament or by the state legislature because it is a court of record. So very basic and means that ordinary type of questions are there. At least उतना तो prepare हो जाएगा. So daily, if you say daily I will take such a quiz, it will hardly take you 1 or 2 minutes. And please participate in the quiz. है ना? उससे we'll increase question to 10, 20. At least उतना तो हमारा prepare हो रहा है ना. चलिए. Anyway, so we will start with the meaning of the word tribunal. ठीक है. चलिए. The word tribunal originates from the Latin term tribunes, which means raised platform with the seat of judge. So basically in Roman Empire it was happening. There was a raised platform, and on that raised platform judges used to sit. And from there the word tribune was there. And there's a newspaper also, the Tribune. Tribune means जो ऊंचाई पे बैठे, top one. And from there the word tribunal has come. Now what are tribunals basically? See, uh, we are having our courts. ठीक है, थोड़ा समझना है इसको. We are having our courts. We are having Supreme Court. We are having our means this High Court है ना, lower court. Complete hierarchy we are having. Now these courts, they are having, now the courts are working on the principle that even 100 culprits might go scot free, but not even an innocent person should be put behind the bars. And in order to save that innocent person, they have to follow a very technical and a very detailed procedure. Number of appeals are there, appeal from single bench to the double judge bench, from there to this court, then to this court, and every appeal involves time. 3 month टाइम फॉर दिस अपील, 9 month टाइम फॉर दिस अपील, देन किसी का वकील नहीं आया, कभी किसी का वकील नहीं आया, देन अगेन सम एविडेंसेस आर कमिंग, मींस इट टेक्स years and years. Why this so much time is being consumed by these ordinary courts? Because they are following technical procedures like your CRPC and CPC, particularly your CPC, Code of Civil Procedure. And because of these hectic, detailed procedure, the decision making of the courts have become very delayed, and that's why it is taking so much of the time. So, as an alternative means the court case would not go to regular court. We have an alternative body which is giving us speedy justice, that is tribunal. ठीक है ना? So tribunal is basically an example of alternative dispute redressal mechanism, that in some alternate way we can means resolve our disputes in some ordinary court, or some ordinary body is there, some alternative body is there which is trying to resolve our issues, that is called tribunal. So these are adjudicating means there are two parties which are having means rival claims, ठीक है, and there is a law in between, ठीक है. So according to a law, so if you see any type of legal agreement, then if any type of legal agreement, it create a set of duties and create a set of rights. Suppose the agreement is there in between A and B, that means A is having some duties and B is having some rights, like you and Unacademy. It's you and Unacademy, you have paid fees, that means Unacademy is having a duty to teach you and you are having a right to teach you. Getting my point? Any legal agreement, it is in this format only. So this person is not performing its duties, and a case between two bodies, and during the that adjudication process, the court also used to interpret the laws. ठीक है? Now see for example, A and B, ये आपको सुप्रीम कोर्ट में भी काम में आएगा. A and B entered into an agreement, right? A and B entered into an agreement according to a law. Now, they are having some dispute regarding their agreement. So means while going through their agreement, the court also have to interpret this law, that what is the meaning of the words which are written in that law. So that is a judicial function. Now, what can be quasi-judicial? Means those persons who are sitting in tribunals, they basically, some of them belong to executive. They might be your IAS officers. They might be your defense personnel, like in that armed forces tribunal, they're defense officer, but they are performing a judicial function. That's why we say that it is a quasi-judicial function. A tribunal is any person, it might be single member only, or a body of person having to judge, adjudicate, or on or determine claims or disputes of specific nature. Now in courts, what is happening? All type of cases are going to court, but tribunal is made for a very specific purpose, like your railway tribunal. You know, we will see some of the types of tribunal, like your railway tribunal. ठीक? Now, this railway tribunal, it will accept only some specific category of cases arising out of railway and their employees. Clear? So what we are intending to do, we are trying to make a specific body so that some specific type of cases would go only these tribunals, and this burden on the regular court that can be decreased so that they can work in a speedy manner. Okay, thank you, Mr. Raji. Thank you. ठीक है? Then it is created under a statute. Statute means law. It is created under a statute and adjudicate upon specific matters under that statute. So we are passing a law, and by that law we are creating a tribunal, and the tribunal is going to listen. It is going to adjudicate only those cases which are given to that particular tribunal. Just for example, see your CAT, or Central Administrative Tribunal. By which law it is being established? It was established by Administrative Tribunals Act 1985. Now, which cases it would hear? It would cases involving government and its employees, central government and its employee service rules issues are there, agreement issues are there, disciplinary action has been taken by the government against you, and you are not satisfied with that action, you think you are right, wrong has been done with you. All such cases means personal related cases, they will go to this administrative tribunal. Getting my point? So there are alternative mechanism to resolve, to adjudicate cases, to solve cases, and means they are uh, they are entertaining only some specific matters. Similarly, we are having competition appellate tribunal, It was created by Competition Act of 2002. ठीक है. Now, if competition commission is there, it is giving some decision, you are not satisfied with the decision, you can go to competition appellate tribunal. Similarly, cyber appellate tribunal is there under Information Act of 2000. Now, if under now suppose an officer under Information Act means उसने आप पे कुछ कार्रवाई की है, you have been booked under Information Act, where you should go, where you should appeal against that officer, not in courts, because courts are already overburdened by regular cases. We are having a separate body for that. What is that separate body? Cyber appellate tribunal. ठीक है. Similarly, we are having GST appellate tribunal made under the GST Act of 2017. Now, suppose government imposes, means officer came and officer gives you a fine. He imposes a fine upon you for non-payment of GST, but you think that you have paid GST. That fine is not means done. That fine is not appropriate. Where you can go? You will not go to court because courts are already overburdened. For that these issues we are having a separate body, that is our GST appellate tribunal, right? So, in case you have to make appeal against any officer for a claim of GST, where you should go? GST appellate tribunal. So, n number of such tribunals are there, and they are created by a separate law for some specific purpose. ठीक है ना? So what we are doing, we are trying to create some additional bodies or some alternative bodies so that the burden on the courts can be reduced. That is the basic purpose of making a tribunal. ठीक है. Now, what is the need or rationale for tribunal? What is the significance for tribunal? Whatever question come, you have to write the same answer. Need, rationale, significance, whatever. The strict rules of pleading. Pleading means that I have told you at the beginning of the class that there are so many procedures, so many appeals, evidence, tardy trials, 3 or 4 tier appeal. It is a very general thing that 3 or 4 tier appeal is there. Then your case will go to High Court. From there, it will go to Supreme Court. कब decision आएगा? Your life will pass, but decision will not come. Endless revision, है ना, reviews had resulted in docket explosion. Now, what is this word docket explosion? It means delay in justice. What did this mean? It means delay in justice. So, means courts are totally overburdened. We are having very less number of courts, and we are having 130 crore of population, where people among themselves are having issues, people with government are having issues, your personal matter issues are there, your professional matter issues are there. How many matters are going to go? Hello, Mohit. Now, how many matters are going to be there in the court? So we need an alternative mechanism whereby we can have, see, this is your court. It is totally overburdened. It is overburdened. That phenomena is called docket explosion. Now, what we do? We make individual bodies. This for some specific purpose, this for other purpose, this for other purpose, suppose this for GST purpose, separate purpose, individual bodies made so that the burden here can be reduced. So thus there was a need for alternative adjudicating forum which is cheap. Not you have to pay so much of fee to your lawyer, so much of fee to the court and all that, which is fast. दो तीन सुनवाई होती है, decision will come, which is decentralized. Decentralized means that it is at the district level, है ना, and less formal. No, that means it works on the principle of natural justice. Common sense के हिसाब से काम होता है. No need to go through those written rules everywhere, rules and rules. It works on the principle of natural justice and is flexible in its approach. No tardy rules or no strict rules or rigid rules to follow. Welfare state. Then welfare state resulting in huge size of government. Now our DPSPs, if you remember, particularly Article 38 and Article 39, they try to establish a welfare government in India that where from womb to tomb, whether I should say it is womb to tomb. When you are in your mother's womb and when you are died, you are inside the earth to tomb, everywhere government is with you. ठीक. यहाँ पर when you are in womb, पहली बात पेरेंट्स का मैरिज रजिस्ट्रेशन कौन कराएगा? गवर्नमेंट. ठीक है. टीके कौन लगवाएगा? हु इज गोइंग टू गिव वैक्सीनेशन टू मदर? अल्ट्रासाउंड कौन कराएगा? जांच कौन सी होगी, कौन सी नहीं होगी, ये वाली जांच होगी, वो वाली जांच नहीं होगी, हु विल टेक केयर ऑफ दैट? गवर्नमेंट, है ना. यू कैन नॉट गो फॉर सेक्स डिटर्मिनेशन. हु मेड द लॉ? गवर्नमेंट. यू हैव टू डू these टाइप्स ऑफ अल्ट्रासाउंड, these टाइप्स ऑफ वैक्सीनेशन कहाँ लगेंगे? इधर इन अ गवर्नमेंट हॉस्पिटल रन बाय गवर्नमेंट और इन अ प्राइवेट हॉस्पिटल विच इज रेगुलेटेड बाय द गवर्नमेंट. देन यू आर बॉर्न, बर्थ रजिस्ट्रेशन कौन कराएगा? गवर्नमेंट. Vaccination, government. Schooling, government, either in a government school or in a private school which is controlled by the government. College, government. Employment, income tax, this tax, that means everywhere there is government, and it ends with your death certificate. And if you are having pension, then again, even after your death, your government is there, like LIC. जीवन के साथ भी जीवन के बाद भी, again LIC is also government. It comes under the definition of state under Article 12. That means everywhere there is government, and where there is so much of bureaucracy, everywhere there is government, that means there are cases also, because people sometimes people are not satisfied with the working of the government. Where they will go to court. And that's why, because of this welfare state, there are so many cases pending in the court, because I think around in 60% of the cases in courts, one party is your government, either state government, local government, or national government, but one party is the government. Then there's need for expertise, as many disputes are of exceptional technical nature, like a dispute concerning your cyber crimes. Now, the regular judges who are sitting here in the Supreme Court, High Court, District Court, and the lower court, they are students of law. They are not technical person. They are not engineers or means like organ donation. So they are, these judges. They are totally means incapable of handling such technical things. So we need some type of means remedy, some type of arrangement where we can have judicial members, person belonging to judiciary, where we can have persons belonging to administration also. ठीक है? And where we can have some technical experts also. Such type of adjustment or such type of arrangement that we have done in tribunals. So tribunals can comprise of judiciary member which can tell that what is right according to law. They can comprise of administrative members who are experienced in means day-to-day administration, and it can comprise of technical experts only. ठीक है? चलिए, so these are the various reasons because of which there was a need for some alternative mechanism, and that we have found in the name of tribunals. ठीक है? चलिए. Now, what is the difference between your regular courts and your tribunals? Now, courts are constituted by the state as a part of hierarchy of the state. This is your hierarchy of state. This is the judiciary. At the top, we are having Supreme Court, followed by High Court, followed by District or Sessions Court, whatever you say, and followed by subordinate judiciary. ठीक है? Whereas tribunals, they are constituted under a law or statute to exercise special jurisdiction, means specific, like GST, that uh, GST appellate tribunal. It would entertain cases only of GST and no other cases. Similarly, your CAT, Center Administrative Tribunal, it will entertain only cases relating to disciplinary action, promotion, demotion, all that cases of central government employees and nothing else. All courts are tribunal, but all tribunals are not court. Now, how all courts are tribunal? Now, see, what a court is doing. Court is adjudicating between two bodies. The same work is done by tribunals only. So, it is like this. This is your tribunal. This is your, sorry, this is your court. This is your tribunal. These all courts are tribunal, but all tribunals are not court. They are not court. What is tribunal? Tribunal is a specific arrangement. Okay? A court can try all cases except those which are exempted out of the jurisdiction of the court. जैसे for example, under I think Article 262, yeah, under Article 262, Supreme Court cannot entertain cases of interstate river water disputes. Supreme Court cannot entertain. Means so, but it can entertain all those cases except those which are exempted. Whereas tribunals, tribunals can try only those cases which are given to you, like this one. Courts are bound by courts of procedures and evidences. This can be your, this can be your CPC, Code of Civil Procedure. This is Indian Evidence Act. They are bounded by those evidence. जज के सामने एविडेंस खड़ा हुआ है, लेकिन अगर वो एविडेंस एक्ट के अकॉर्डिंगली प्रॉपर एविडेंस नहीं है, जज कुछ नहीं कर सकता. दे आर सिंपली बाउंड विद रूल्स. जजेस आर एक्सपेक्टेड टू वर्क इन अकॉर्डेंस विद रूल्स ओनली, लॉ ओनली. बट tribunals tribunals work on the principle of natural law. They make their own procedures. That's why when need comes, they used to change their procedures also. That's why they are very flexible. That's why they are giving judgment in a time bound manner. Judges are independent of executive, whereas terms and conditions of service of members of tribunals are decided by the executive. Now, this is something problematic. Why? Because executive is appointing the what? Members of tribunals, and their terms and conditions, their tenure, their salaries, everything is decided by the executive. Now suppose government appoints a tribunal. थोड़ा समझना है इसको, हाँ? Where is the problem? Because we are nowadays we are making more and more tribunals. That's why it is becoming tribunalization of justice. For this case, go to this tribunal. For this case, go to that tribunal. For this case, go to that tribunal. तो भाई फिर कोर्ट काहे के लिए खोल रखे हैं? कोर्ट क्या करेंगे? कोर्ट बंद कर दो. For every second or third thing, we are having a separate tribunal. Means service related matter, go to CAT. GST related matter, go to this GST appellate tribunal. For railway related matter, go to railway tribunal. For consumer matter, go to this tribunal. तो फिर कोर्ट काहे के लिए है? ठीक है. तो this phenomena of making more and more tribunals, that is called tribunalization of justice. For mains it is very important. ठीक है. Now suppose government created a tribunal. The members of tribunal are appointed by the government only, because in court who is appointing? Judiciary itself. But here government is appointing. Now this tribunal is entertaining a case which is between government and me. Now what will happen? Getting my point? This tribunal is entertaining a case which is between government and me, Amit Yadav. So, means those members who are the acting like judges in this tribunal, they are appointed by the government only, and they are listening to a court which is, in which government is itself a party. That means government is becoming a judge of its own. That is the problem with tribunalization of justice. That is the only issue with tribunals. Otherwise, these tribunals are very good. I think you are getting my point. So what is the issue? The issue is that government is creating tribunal, government is appointing the judges in the tribunal, and those judges who belong to government, those administrative members, technical members who are appointed by government, they are listening to a case in which government itself a party. That means the government is becoming a judge of its own. That's why फिर fair hearing की उम्मीद आप कैसे रखोगे? So that is the problem which we will see later on in this class only. Then courts can declare a law is unconstitutional, violative of basic structure, है ना, fundamental rights, whereas tribunals cannot declare a law as unconstitutional. So this is a basic comparison, basic difference between your courts, regular courts, and your tribunal. So I think regarding tribunals, everything is good except one thing, that the members of a tribunal, those who are making judgment, they should be independent of the government, because in 60% of the cases, government itself is a party. Now, how can you imagine that government that there would be a free trial? Because government is appointing those men. भाई मेरा जो अपना वाला है मैंने उसको appoint कर दिया, and that is the issue with Supreme Court also. Why we are having collegium system? Why president cannot appoint its own judges? वो भी तो कर सकते हैं, but क्यों नहीं करते हैं? Because when government cases will come, then the person appointed, judge appointed by the president or government only, would support the government. Same is the issue here also. यहाँ थोड़ा इनको इंडिपेंडेंट करने की, रिफॉर्म करने की हमको जरूरत है. अदरवाइज दिस मॉडल इज वेरी गुड. चलिए. Now there can be various types of tribunal depending upon mandate. Mandate means which particular type of or category of cases they would hear. Because मैंने आपको बताया कि they would look into only very specific type of cases which are given to them. What type of cases? Likewise, tribunal for adjudicating service matters of public servant. Example: Central Administrative Tribunal or CAT. Likewise, your officer have demoted you, government has suspended you, है ना, they have means बर्खास्त कर दिया, removed you from service, or transferred you, which you think is not according to rules. Where you can appeal? You can appeal to CAT or Central Administrative Tribunal. But again the problem is same. If here those people are appointed by the government who are working, who are favoring the government, then who is going to give you justice? Because they would favor the government, not you. So independence of the judges in a, or the members of a tribunal, it is of prime importance. It should be ensured. And also it is violation of Article 51, sorry, Article 50, separation of judiciary from executive. Secondly, for matters relating to armed forces, we are having armed forces tribunal. It will deal only with the members matters of armed forces personnel. Similarly, tax related matters are there. For that, we are having an example of GST appellate tribunal. For environment related cases, they would go to a separate tribunal, that is your NGT or National Green Tribunal. ठीक है ना? So I think by now the basic thing is clear that courts are very overburdened. There was docket explosion in the court. Means long queue was there, never ending queue was there. And why that queue was there? Judges are there, judges are working throughout the day, they are working hard, but why the queue is not ending? Because of two, three reasons. First, because of welfare state, the government activities have so much increased that disputes are there to arise. वो तो आएंगे ही आएंगे. Secondly, the courts are bound with very technical, detailed, and very strict procedure. They have to follow that procedure. That's why each and every single case is taking very much time. है ना? So, in order to remove these difficulties, we need a tribunal where specific tribunals are there for hearing some specific type of cases. So, these are some of the examples. That is the basic model. Now, see, what are the characteristics of tribunals? You can say features also. Firstly, they are of statutory origin, means a tribunal is formed by a law. Like GST Appellate Tribunal is formed by a GST law, GST Act. Okay? They established under a law. If it is of a subject of state list, then this law would be made by state legislature. If it is of union list, then it will be made by parliament. ठीक है? लाइक पार्लियामेंट वाले हमको 323A में मिलते हैं, स्टेट वाले बी में मिल जाते हैं. दे आर क्वासी जुडिशियल बॉडी, मीन्स दे आर नॉट रेगुलर कोर्ट्स, बट दे आर दोज बॉडीज which are performing functions similar to that court. So quasi judicial means you are not a court, you are not a judicial body, but still you are performing judicial function. इसमें कभी भी quasi में confusion होना, मैं आपको एक ट्रिक देता हूँ, उससे याद हो जाएगा. Now see, when we say that Indian constitution is quasi federal, then what does it mean? When we say that Indian constitution is quasi-federal, then what does it mean? It is half unitary, half federal. It is federal functioning like unitary, or it is unitary functioning like federal. ये भी तो है ना. क्या क्या मतलब होगा इसका? ठीक है, तो मीन्स इट इज unitary which functions like a federal. That's why we say Indian federalism, which functions like a federal constitution. ठीक है, a boy having feminine features, इससे याद हो जाएगा. बॉय हैविंग फेमिनाइन फीचर्स, क्या बोलोगे इसको? क्वासी बॉय, क्वासी गर्ल. ही वुड बी कॉल्ड क्वासी गर्ल. He is not a girl, but he is functioning, behaving like a girl. That is the meaning of quasi. So quasi judicial means these are not judicial body, but they are working like judicial body. They work on the principles of natural justice. ठीक? Now there are only two principles of natural justice. First, no person can be a judge of his own, and second, no person can be punished except by giving him an opportunity to be heard. पहले उसकी बात सुनो, वो क्या बोल रहा है. You know, so any law must contain these two provisions of natural justice. They can devise their own working procedure. They are neither bound with Code of Civil Procedure. They are nor bound with your Indian Evidence Act and nothing. They can devise their own procedure. That's why it is very flexible. जब लगता है वो उसको change कर लेते हैं. They have the power to summon attendance, administer oath, and ask for production of documents. Writs of certiorari and prohibition can be issued against them when in the working of some tribunals there is a violation of some fundamental right. Then court can issue certiorari and prohibition against them. Their decisions can be challenged before Supreme Court and High Court. तो फायदा हमें क्या मिल गया इसमें कि the time taken in the lower courts, the time taken in the lower court. Earlier, what was happening? This is your judiciary. The court was entering here. From here, it comes to district court. Then from here, it comes to high court. Then it comes to Supreme Court. And then revision petition, review petition in Supreme Court also. तमाम सारा टाइम. अब क्या होगा? Decision is given by tribunal, and from tribunal, if you're not satisfied, then you will go directly to the high court as an appeal against tribunal. So ये जो पूरा टाइम था, ये आपका बच गया है. चलिए. Now, tribunals in India, because generally it is believed that the history of tribunal starts in India with the 42nd Amendment Act by Indira Gandhi. उसकी भी अपनी कहानी है. Now, Indira Gandhi wants to have a committed bureaucracy. Otherwise, we have a neutral bureaucracy, but she wants to have a committed bureaucracy where the bureaucracy is working for the implementation of the government policy means in favor of a party particular. ठीक ठीक है. Some of the many of the officers were there जिन्होंने बोला no madam we cannot do this. What now government will do? Government will take action. Against action they will go to court, and government do not want them to go to court. What government did? They established tribunal like cat. Now where you have to go? Now you have to go to cat. And who is sitting in cat? Those officers appointed by the government only. And in whose favor they are going to give decision? They are going to give a decision in government's favor. That was the purpose when it was introduced by Indira Gandhi, is to control bureaucracy. That was the purpose. Anyway, but even before this 42nd amendment, there was provision in constitution about tribunal, and also we were already having a long history of tribunals in India. So for the first time, tribunal in India can be traced to Income Tax Appellate Tribunal in 1941, which was established by the British government. Now, what happened in this? ठीक है ना. Suppose an income tax officer is there and he say, भाई your assessment for income tax for this financial year is suppose 5,000 rupees. You say no, it is 2,000 rupees only. Bole, no, no, it is 5,000 and I am going to impose a penalty upon you. Now, where you would appeal? You would go to court. So what British government did? They established income tax appellate tribunal. You would not go to court against that officer. You will go to this tribunal. So in 41 itself, we were having a tribunal. Now this word tribunal is nowhere defined in the constitution. However, it was there in Article 136 and Article 227. Always remember, ये प्रीवियस क्वेश्चन पूछा गया है that in Indian constitution where you can find word tribunal. Majority of the students says कि in original constitution there was nothing like tribunal. It was added by 42nd Amendment Act under Article 323. No, no, no. Under 136 special leave petition अभी क्विज में क्वेश्चन था इसका, था ना. प्लीज डेली अटेंड दैट क्विज, वो बिल्कुल किया करो आप लोग. इट इज वेरी hardly take 1, 2 or 3 minutes, but at least your 50 statements are getting revised. ठीक है. So 136 special leave petition, in that it is written that Supreme Court can give special permission of appeal against decision of any court, any tribunal, anything in India. So there it is mentioned. Similarly for High Court it is given in 227. So in these two articles the word tribunal was already there. In fact, in 1966, the first ARC also recommended setting up of Civil Services Tribunal to deal with the service matters of civil servants. Then, in 1970, the Vanchu Committee proposed setting up of Income Tax Settlement Commission. Why? It was also a form of tribunal. Why? Because income tax matters are going to court. Now, suppose income tax matter, there is an income tax matter or any tax related matter which involves a sum of rupees 10 crore. Assessment है, issue है कुछ, sum of rupees 10 crore. Now matter is going to court. In court, it is normally civil matter, it is going to take around 20 years. Now for 20 years, this money is blocked. This money can be neither used by the government nor by the person upon whom it is claimed. So this money is totally blocked. है ना. And in this way, a huge large sum of money was blocked. So Panchu committee proposed setting of income tax settlement commission. Then JC Shah committee or High Court's arrear committee, arrear means pending cases, suggest to create an independent tribunal to deal with docket explosion. This I have told you. Docket explosion means a high number of pending cases in the court. So उन्होंने बोला कि भाई such a large number of cases are pending, we need a separate tribunal to deal with how these cases can be solved. Then the Law Commission, in its report in 1974, again recommended for the setting up of a tribunal. Then Swan Singh Committee advocated setting up of administrative tribunal. This your 42nd Amendment Act of 1976. Not only your fundamental duties, please do remember, not only fundamental duties, but the complete 42nd Amendment Act was on the recommendation of Sardar Swan Singh Committee. ठीक है. One homework I will give you today, and in tomorrow's class I will ask you. Everybody of you must have gone through that Indira Sahani case under Article 16. सबने पढ़ा होगा. लक्ष्मीकांत में दिया है, डीडी बसु में दिया है. Every one of you must have gone through that Indira Sahani case. ठीक है. In that case, there was a provision for creamy layer for OBC. है that there should be a creamy layer for OBC. उसका क्राइटेरिया अलग अलग है, 9 lakh rupees salary, 8 lakh salary, no constitutional post whatsoever. Now my question is that on which committee's recommendation this creamy layer was introduced? I don't know why this very important fact has always been overlooked by the examiner as well as by the authors and as well as by the students also. Majority of the committees we are studying, but such an important committee, Justice Jain committee, थोड़ा सा क्या है पढ़ना, such an important committee which has given that oh, a creamy layer should be there and this should be a criteria for creamy layer. Nobody studies that. So similarly, this complete 42nd Amendment Act was on the recommendation of this committee, not only your fundamental duties. कभी confuse हो, तुक्का मारना हो, always go with Swan Singh committee. So they recommended two type of tribunals in India. First, administrative tribunal for under central law for central and state government employee service matters, and second, tribunals to resolve disputes of revenue, land reforms, procurement, distribution of food grains to be decided by tribunal. These two type of matter, they should not go to court. Okay, what they say? These two types of matter, they should not go to court. All of you who have not joined my the Telegram channel, you can please join me so that you can get notification of my upcoming this YouTube as well as special classes. My Telegram channel is in the name of Amit Yadav Foundation. You can search by this name on Telegram. You will find only one channel with a picture of mine. You can join it. Then my special classes, quiz, every notifications you can got from there. This is on Telegram. Okay? This is also my referral code for Unacademy. Whenever you download the app, if it asks for some code for free classes, please use this code and you will get free classes. All the free material you will get, free classes, test series, quiz, everything you would get just by using this code. If it asks, if it is not asking, simply go to classes. But if it is asking for some code, then you can use this code. Chaliye. So two type of matters they say should be decided by the tribunals. They would not go to court. First was service matters of central and state government employees, and second was matters of revenue, land reforms, and all this. Now, uh, accepting the report of this Sardar Swan Singh committee, 42nd amendment was made, and it added part 14 in the constitution, which reads the tribunals. Right? Part 14, Tribunal, it contained two articles to 323A, 323B. Since both of them have capital letter, that means both of them were added later on after the original constitution. Okay? 323A, 323B. Now 323A, what it provides? It provides for a tribunal for service matters. दो चीजों की भी कमेटी ने बात की थी ना, स्वर्ण सिंह कमेटी ने, फॉर सर्विस मैटर। इसको हम देखते हैं डिटेल में, जस्ट होल्ड ऑन फॉर अ मोमेंट, वी विल सी दैट इन डिटेल। क्या बोल रहे हैं? पार्लियामेंट में बाय लॉ प्रोवाइड फॉर एडजुडिकेशन ऑफ ट्रायल बाय एडमिनिस्ट्रेटिव ट्राइब्यूनल्स of disputes. Administrative tribunal means tribunals which would deal into administrative service related matters and complaints with respect to recruitment and condition of service of person appointed to public services and post in connection with the affairs of the union or of the state or of any local or other authority. इन सबका मीनिंग कहाँ मिलेगा? यूनियन, स्टेट, लोकल, अदर अथॉरिटी, आर्टिकल 12 में, or within the territory of India or under the control of the government of India of any corporation owned or controlled by the government of India. Now, कितने आ गए इसमें? First, union government. Second, state government. Third, local government. Fourth, your government companies. Fifth, government corporations. All of them, okay, government corporation, all of them, their employees, service related matters like promotion, demotion, transfer, all those matters, they would not go to court. For them a single administrative or administrative tribunal would be there, and that tribunal is going to entertain those cases. Okay, and how it would be made? First, parliament would make a law, and under this law parliament would establish a tribunal. Secondly, a law made under clause 1 means this law Provide for the establishment of an administrative tribunal for the union and a separate administrative tribunal for each state or two or more states. Now, this is very, very confusing. 99% of the students confused in this got confused in this provision during examination. Now, question can be very simple. है ना? Just try to answer it. Question can be very simple that administrative tribunal for uh, service matters under state government under state government is made by is made by a law made by state legislature, a law made by parliament. 99% of the students use common sense and they tick the option that it is made by state legislature. No, dear, no. It is made by Parliament. It is a unitary feature. Although it deals with the service matter of state government employees, but the law is made by Parliament under Article 323A. So provide for establishment of separate tribunal for the union and separate tribunal for each state. But the law is made by Parliament only. Okay? Then specify the jurisdiction, powers, including the power to punish for contempt, इस पे थोड़ा सा देख लो. Now, what is the power to punish for contempt? Simply means that you are not following the command given by the court, or you are simply not following the orders of the court. Now, this contempt, it can be of two type. One civil, and second is your that camera type, that is criminal. One is civil, one is criminal. ठीक है? Civil means court have asked you to give you some compensation to somebody, to deposit some money into the court or treasury, which you have not done. That is called civil. Criminal means you have defamed the judiciary, you have defamed the judge, you have made personal allegations regarding regarding the intention of a judge while giving a judgment. You are interfering with the administration of justice. That is called क्रिमिनल. आपके वो जज थे, क्या नाम था उनका, प्रशांत भूषण केस, है ना, देन योर दिस कुणाल कामरा केस, दे आर ऑल अबाउट criminal contempt of court. But I think there are very fewer cases of criminal contempt of court. Nobody is talking about civil contempt of court, and I think in this year UPSC mains they can ask a question regarding this. Nobody is talking about civil contempt of court where more than 50,000 cases are pending in the court, but nobody is talking about them. Why if the court is ordering to deposit money, why people are not depositing money? Nobody is talking about that. All are talking about Kamra, Prashant Bhushan. ये थोड़ा sensational है. That's why. है ना? But you, whenever you are studying contempt of court, first focus on civil part, then criminal part. Then it provides for procedure, blah blah blah. Then it excludes the jurisdiction of all the courts except that of Supreme Court under Article 136 with respect to disputes or complaint refer. Means against that your this tribunal, you cannot go to any court except Supreme Court, that too under special leave petition. But this provision has been declared invalid by the Supreme Court. Why? Because judicial review is a part of basic structure of the Constitution. You cannot exclude jurisdiction of Supreme Court or High Court except as given by Constitution. So, well, this only. That's why that means that against this decision of tribunal, you can go to High Court as well as Supreme Court, that we have already seen. Then it provides for transfer of each such administrative tribunal of any cases. ठीक है, means before the formation of tribunal, those similar cases, similar matter cases which were pending in the courts, they can be transferred to now to that tribunal. है ना, ये उतना important नहीं है, छोड़ो छोड़ो इन सबको. These things you can leave. Contain any, this you can leave, this you can leave. You know, they are incidental and चलिए. Then secondly under 323B, under Article 323, I'm sorry this is not is visible to you because too much material is there. Under Article 323, be the appropriate legislature. And please do remember that in 323A, only Parliament would make law, while in 323B, Parliament as well as state legislature can make law. It depends upon that which subject belong to which list. So the appropriate legislator may by law provide for adjudication of or trial by tribunals of any dispute regarding which matters, regarding all these matters. ठीक है. So 323A, it was dealing with service matter of the employee. 323B, under it the legislature can make law, and by that law they can establish a tribunal to deal with these cases. First, levy, assessment, collection and enforcement of any tax. So if the tax is your income tax, then that law should be made by parliament because direct taxes come under them. But if that law is your some means indirect tax, then it could have been made by the states. But now since it is GST, so again it has to be made by parliament. Foreign exchange, import, export across custom frontiers. Again, that such a tribunal would be established under a law made by parliament because all of them belongs to the union list. Industrial and labor dispute. This can be made by a state also. Land reforms by way of acquisition by the state of any estate as defined in 331 याद है ना उसमें माइनिंग राइट्स मैनेजमेंट राइट्स तमाम सारी चीजें डिफाइंड है और राइट्स देयर इन एक्सटिंग्विशमेंट छोड़ो छोड़ो दिस हैज टू बी मेड बाय स्टेट लेजिस्लेचर because land use and land reforms are subject of state legislature. Sealing on urban property. Now what can be sealing? That one family, भाई औरों को भी तो रहना है. One family cannot have more than this much of property because now we cannot afford to have more of horizontal expansion or horizontal growth in cities. Now we have to go for vertical expansion because agricultural land नहीं तो नहीं बचेगी. ठीक है. So that is ceiling on urban property. Election to either house of parliament or house or either house of legislature of a state, but excluding matters referred to in this article and this article. Means there can be a tribunal and any means case relating to the election under Representation of People's Act. वहां से केस कहाँ जाएगा? Normally it goes to High Court, but if Parliament is making a law, then that that case will go to tribunal and not to High Court. Then production, procurement, supply and distribution of foodstuffs like in your PDS, है ना, राशन की दुकान, and such other goods as president may declare to be essential goods for the purpose of this article and control of prices of such goods. So if there any cases there regarding prices, regarding means hoarding, regarding black marketing, then such cases will not go to court, they will go to a tribunal. हालांकि ये सभी बन सकते हैं बट गवर्नमेंट ने बनाई नहीं है बहुत सारे तो बनाई नहीं है rent its regulation and control and tenancy issues including right title all these things means for all these things also parliament और state जिसका भी सब्जेक्ट है they can make a law and by that law they can establish a tribunal ठीक है तो कहने का मतलब कुल मिला के ये है कि all these matters now they will not go to regular court where they will go they will go to specific tribunals so that speedy justice and timely justice is there ठीक है but if for each and every matter if we are going to have a tribunal then where is the court so it will become tribunalization of justice for this matter this tribunal this tribunal this tribunal this tribunal this tribunal everywhere you are having tribunal tribunal and tribunal and tribunalization of justice is okay ठीक है because we are having speedy justice but the problem is that in those tribunals the executive should be separate from judiciary you know that thing is to be ensured otherwise it's okay otherwise तो फिर ठीक है that is a solution for docket explosion which we are having in our court चलिए so this was all about tribunals and ये छोड़ छाड़ो this you can go or let me finish them also now a law made under this clause 1 means the law जो भी बनाया है this law these laws should provide for the establishment of a hierarchy of tribunals means by a law a hierarchy of tribunals can also be like this इसको समझ लो अच्छा suppose this is tribunal number 1 tribunal number 2 tribunal number 3 and this is for suppose your cases of rent ठीक है now if you are having any case regarding rent between landlord and you then that case will not go to court it will go here if you are not satisfied with this decision you can go here then you can go here so that is called a hierarchy of tribunals means appellate authorities specify jurisdiction powers and all the I think same things are there these are all those things which we have seen in this law this these would be the features of that law under 323A. Similarly, these would be the features of that law which has to be made under 323B. ठीक है? So I think your point is clear or let me make it more clear. खाली पेज चलिए. So we are having 323A, we are having 323B. Under this, law is to be made only by a parliament. What it would provide? It would provide for the establishment of tribunals. First tribunal to dealing with the service matters of union government employees. Second tribunal for each state to deal with the service matters of state government employees. But the law should be made by parliament. This tribunal under this law can be made by parliament as well as state. Under this law, a separate tribunals would be established. Under this law, separate tribunal. It can be for tax purpose, rent purpose, reforms purpose, है ना बहुत सारे purpose हैं. All those purpose which we have seen these matters. Levy, assessment, collection, labor dispute, industrial dispute, urban property, house of so many. That means whenever a question comes regarding judiciary or somewhere you have to give opinion, then one very good opinion which you can give is regarding the establishment of tribunals. Like your commonly your PSC matters. PSC is taking MPPSCs or UPPSCs or UPSC is taking examination. Students are having issues. They are going to court. So one very good solution can be there that form a tribunal. And all such cases they would go only to that tribunal and not to court so that speedy justice can be there. Okay? Chali, so I am ending the class here only. Thank you very much for being in class. At least try to attend the class and try to attend that quiz daily. है ना फ्रॉम टुमारो आई स्टार्ट एट अराउंड आफ्टर 15 मिनट्स since the start of the class तब मैं शुरू करूंगा 15 मिनट बाद so that majority of you can join but try to attend that quiz. Suppose if 10 questions are there that means 20 or 25 statements are there at least 2 या 3 मिनट में वो 25 statements तो आपके कवर हो गए ना वो तो रिवाइज हो गए आपके that you know very well कि भाई which statement is right which statement is wrong and they are very very basic type of statement those statements जिसमें आपको ज्यादा confusion रहता है because these questions they are not put by me these questions they are put by Unacademy only. ठीक है ना ओके कृष्णकांत वेलकम 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 मोहित चलिए थैंक यू वेरी मच see you tomorrow at the same time 5 with a new topic हाँ from 2nd of December I'll take topics in continuation अभी तो ठीक है I have randomly picked some topics and I'm taking class randomly on those topics but from 2nd or 3rd of December what I will do I will is continue these classes in a forward manner we start from the beginning and we will finish at the end means complete polity or at least a complete part like part 3 part 4 complete part we will do so that means after 1 week you would have done something substantial कि चलो भाई इतना तो हमारा पूरा रिवाइज हो गया ठीक है सो bear with me up till 2nd or 3rd of December तब तक I am picking the topics from between and taking class on चलिए thank you very much thank you